Namaskar, this is Tulja Bhavani. I welcome you all to my online classes in law, especially to the wing of business law. Dear viewers, this is a course which is specifically designed for the BCom students online having 6 credits, BCOC 133. So, today we are going to learn about breach of contract and its remedies. Dear viewers, in our previous class, we have learned about discharge of contract. Discharge of contract means putting an end to the contract, and a contract can be discharged by two modes. One is in two ways, one is in positive way, another one is in negative way. So, in case of positive way, the contract gets discharged by performance of contractual obligation, and on the other hand the contract gets discharged on non-performance of contractual obligation if either of the party to the contract breaks their contractual obligation. It is called as breach of contract, means breaking the contractual obligation. Let us assume that there are two friends, Ram and Shyam. Ram made an offer to his friend saying that, Shyam, Mr. Shyam, will you buy my mobile phone for 10,000 rupees? Shyam has accepted to purchase the mobile phone. Here Ram has failed to give the mobile phone to Mr. Shyam, and Ram claimed 10,000 rupees from Mr. Shyam. So, Shyam has done his part of obligation of paying the amount without receiving the commodity by trusting his friend, but Ram has failed to supply the mobile phone to Mr. Shyam. So, it is a case of breach of contract. Breach of contract means non-performance of contractual obligation by either of the party without any lawful excuse. So, when breach of contract take place, the aggrieved party has a right to file a case in the court of law and claim the damages. So, what are the different kinds of breach of contract? So, there are two different kinds of breach of contract. One is actual breach of contract and the other one is anticipatory breach of contract. Actual breach of contract. In case of actual breach of contract, the non-performance of contractual obligation by either of the party on the day or during the performance. Actual breach of contract will take place when either of the parties to the contract break their promise of performing the contract on the day of contract or before the day of contract, and whichever party is affected by this act has a right to reject the contract and sue for damages. In our example, I have given you the example of Ram and Shyam. Here the aggrieved party, the affected party is Mr. Shyam. It is up to Shyam whether to continue with the contract or to reject the contract. Here Mr. Shyam has to wait for few more days to see that his friend will hand over the laptop to him, or he can demand his friend to give the laptop or the mobile phone to him, or to compensate him for the loss suffered. Instead of waiting, instead of giving you 10,000 rupees, I would have purchased a mobile phone from the market. So, now the same mobile which I wanted to purchase from you for 10,000 rupees is available in the market for 12,000 rupees. It is also a second hand mobile phone. So, instead of waiting for you, I would have purchased outside. So, whatever extra amount now I have to pay 2,000 rupees, apart from your 10,000 rupees, you are supposed to pay me 12,000 rupees. You have a right to either to continue with the same contract or to reject it and claim the damages. The aggrieved party, now the aggrieved party need not perform their obligation. Here Mr. Sham has already given the amount. Now he need not give whatever amount he has given, he has to take back the amount from his friend. Now on the other hand, you have anticipatory or constructive breach of contract. Dear viewers, in case of anticipatory breach of contract, anticipation means assumption or determining in advance. Anticipate means to determine in advance. Here the parties to the contract declare their intention in advance to their opposite party, saying that they are not interested to perform the contract. So when they are not interested to perform the contract, the aggrieved party has the right to reject the contract and to claim for damages. So anticipatory breach of contract is made, it is made by the parties. They declare in advance, they know that they are not going to perform the contract to their fellow being. Let us assume that I want to sell off my ring to one of my friend for 5,000 rupees. Now I am not interested to sell my ring to my friend. I made him a phone call saying that I am not interested to sell my ring to you. I am not interested to sell my ring to you. So here the other party has got an option to reject the contract and claim for damages, or they can ask me the reason why I am not selling. Why am I not selling? Because if I sell this to my friend, I will get only 5,000 rupees, but if I sell the same ring in the market, I am going to get more than 5,000 rupees. I have anticipated, I have told in advance that I am not in a position to perform my contractual obligation. So now we are going to learn about what are the remedies available for breach of contract. Dear viewers, if there comes a problem, then there is a solution. If the contract is not performed, what are the remedies available for the aggrieved party for this contract? Remedies for breach of contract. Remedies means it is a relief which is given to indemnify the loss suffered by the aggrieved party as a result of breach of contract. When we have entered into contract, it was our duty to perform our part of obligation. I have performed my part of obligation, but you have failed to perform the contractual obligation. So due to this, I have incurred the loss. Now what are the remedies which are available to me? So there are 5 types of remedies which are given by the Indian Contract Act to the aggrieved parties. First one is rescission of contract. Second one is suit for damages. Third one is suit for quantum merit. Fourth one, suit for specific performance, and fifth one is suit for injunction. So suit of rescission of contract. Rescission of contract means when either of the party to the contract have failed to perform their contractual obligation, the aggrieved party has a right to challenge the other person to file a case and see their performance is done. But when the party is not doing their performance well, so here the aggrieved party automatically gets discharged from their contractual obligation. I made you to supply the goods. Let us assume that today I have a birthday party. So at my home, so I have given an order for the catering person. So when I have given order to the catering person has prepared the food. He has prepared the food, but unfortunately I am not performing my birthday party due to some clashes at home or some uncertain incident has taken place in my family. So, in the existence of uncertain incident in my family, I am not supposed to celebrate my birthday. So, the other party has performed their contractual obligation. They have prepared the food for 500 people and they are ready to supply it to my home. When they are ready to supply it to my home, I cannot ask them to supply. So, what I have to do? I have not performed my contractual obligation. I told him not to bring to my home, but due to my rejection, he is suffering a loss. So, he has a right to reject my contract and claim for damages. So, he need not make the same, he need not perform his duty towards me, whereas he has a right to claim for damages. Now, who has to pay the amount for 5,000 plates of food ordered? It is me who has to pay the amount for 5,000 plates of food ordered. Now, it is the aggrieved party who can claim the damages from me. This is called as rescission of contract, where the other party is relieved from performance of their contractual obligation. The catering person need not come to my home. Instead, he can keep the food at his catering center and he can sell it to other person. Second one is suit for damages. Suit for damages means it is a monetary compensation which is given to the aggrieved party on non-performance of contractual obligation by the other party. Bhaiya, when you have failed to perform your contractual obligation, but I have done my contractual obligation perfectly, and due to your non-performance, I have incurred a monetary loss. Now, I want you to give me my monetary loss. That is called as suit for damages. In our earlier example, I have given you the loss pertaining to catering services. Now, suit for quantum merit. Quantum means as much as, merit means earned. So, suit for quantum merit. So, suit for quantum merit says that if any party to the contract has performed their obligation, so and at the time of breaking of contract, the aggrieved party, whatever extent they have performed their contractual obligation, they can claim the damages to some extent. Let us assume that I have made a contract with a person saying that please kindly paint my home on the eve of Dussehra. So, my entire building was not yet painted, but the painter has painted three rooms of mine. So, I made a contract with the painter. मैंने अपने घर को I have made a contract with the person to paint my home, and he has not painted the entire home, but he has painted only 3 rooms. So, he can claim the damages of 3 rooms. Next, let me give you another example. Let us assume that I have made an offer to one of my friend asking him to supply me the carpet. So, he has supplied me the carpet, whatever carpet I have asked him to supply, he has not supplied me of that quantity, but he supplied me of little quantity. So, whatever little quantity he has supplied, I am supposed to make him the payment to that extent only. Then comes suit for specific performance. Suit for specific performance means what? So, suit for specific performance, always money is not the compensation which we can pay to a person. Sometimes even performance becomes mandatory. Money can make many things, but money cannot make everything. So, dear viewers, suit for specific performance we were speaking about. Let us assume that old age parents, there are parents who are having a son, the only son, who was taking care of their parents, and due to some incident the son has expired. He has expired in an accident, and the parents are old, they cannot take care of themselves, so they have filed a case against the car owner. The court has given judgment that had their son been alive, he would have taken care of their parents. Now the son is no more. Now it is the duty of the car driver to keep compensating and also to take care of the old parents. This is called as a suit for specific performance, which depends on the individual person's skill, which depends on the individual person's performance. As I told you, another example I will give you, if the for suit for specific performance, it means this contract has to be performed only by you. I was invited by this university to speak on this particular topic. Due to throat infection, I am not in a position to perform the contract. So here I need not pay any monetary compensation, because monetary compensation is not sufficient. So the university has given me a time, 1 month time or 10 days time or 8 days time to get recovered and see that my recording is done here. Then comes suit for injunction. Suit for injunction means at the time of breaking of contract, the parties are not supposed to do something, but they are doing something which is against the term of the contract. So the aggrieved party has filed a case in the court of law, and the court of law has given an authoritative judgment stopping the other party from doing such act is called as suit for injunction. So dear viewers, in our today's class we have learned about breach of contract and its remedies. Whenever a contract is formed, when formation of contract, anything which is formed has come to an end. So as the contract comes to, anything which is formed has to come to an end. A contract is formed and it is enforceable only if it has the 11 essential elements of a valid contract, and a contract gets discharged in a positive mode as well as in negative mode. In a positive mode, if it gets winded up, there is no problem, but if it gets winded up in a negative mode, it is called as breach of contract, where either of the party to the contract have broken their contractual obligation. When they have broken their contractual obligation, what are when they have broken their contractual obligation, the aggrieved party has a right to file a case and seek for damages or to reject the contract. So whatever a rejection is made, on what basis the contract is being rejected is on the basis of actual breach of contract takes place, or anticipatory means at the time of performance it became impossible for either of the party to perform the contract, then the other party has anticipated, they have estimated in advance that performance of this contract is not possible. When you are telling the other party that performance of contract is not possible, then the other party has a right either to reject or to proceed with the same contract. Then we learned about the various remedies which are available for the breach of contract. So remedies for breach of contract is nothing but it is the relief which is given to indemnify the loss which is suffered by the other party as a result of breach of contract. So there are 5 different remedies which are available to the aggrieved party, that is rescission of the contract. Rescission of the contract, as I said, it relieves the aggrieved party from performance of their contractual obligation. The aggrieved party need not perform its contractual obligation. Then suit for damages. If you are not implementing your contractual obligation, the aggrieved party has a right to file a case and claim the monetary compensation from you. Then suit for quantum merit. Quantum merit, as I said, as much as earned. So the aggrieved party has a right to claim the damage to the extent to which it has performed its contractual obligation. To whatever extent they have performed their contractual obligation, they can claim damages to that extent. Then we have spoken about suit for specific performance. As money cannot compensate everything, the court will pass an order to the other party to perform their part of contract, to perform their part of obligation and see that the contract is performed fully. Then we have spoken about suit for injunction. Injunction means it is an authoritative order which is given by the court to the other party for not doing an act which they are not supposed to do. So this was all about breach of contract and the kinds of breach of contract and the remedies which are available for the aggrieved party in case of breach of contract takes place. So thank you so much for giving me this opportunity. This is Tulja Bhavani signing off. Jai Hind, Jai Bharat.